I am live. Let's see. Okay. It's just about 11 o'clock. We'll just wait a couple of minutes here, and then you all can stare at me while we're waiting for my spiel. Assuming anybody's out there and assuming anybody can hear me. I have been told by my tech person that if anybody has any questions, you can send them to me via Messenger. I think that's Facebook Messenger. And if can't answer them during the chat, then I'll be happy to answer them later on. So there's that. I hope everybody, despite everything, is having a good holiday season and staying safe, because that's the key, isn't it? You know, I have learned firsthand that the old adage, and it's trite but it's true, that if you don't have your health, you have nothing. I am a firm believer in that, because when you're not healthy, nothing else matters to a great extent. Oh, I see people. Hey, look at this. Hey, modern technology. Look at that. Haley Sheridan. Haley Sheridan, yay. Steve Johnson. Hey, people I know. There's, I am a prolific Facebook poster, but it's all very family friendly. Most of all of my pictures that I post are typically my fiance and I dining somewhere, or shots with my kids, or more recently, shots of me in my Speedo at poolside after a workout. I am an avid swimmer, and so there are a lot of Speedo shots of Jeff Condon. So I'm sure there's going to be people out there who are my swimming colleagues and brethren, and who are going to be amazed that I'm wearing something other than a Speedo, sort of like the the official lawyer uniform. And for those who are curious, yes, I am wearing real lawyer pants right now. So this is not just me in the top part of a suit. And there goes Snoopy. Down goes Snoopy. I like Snoopy. Okay. Anyway, so hello. I am Jeff Condon, and I am an estate planning attorney. I have practiced in the area of inheritances and trusts and estates for about 32 years. I'm in a business that was taught to me by my father, Gerald Condon, who he passed in 2006. He miss him every day, but he taught me this business. And together with him, I wrote, or we wrote, a book that has since become the best-selling inheritance planning book in American publishing history. It's called Beyond the Grave: The Right Way and the Wrong Way of Leaving Money to Your Children and Others. This is not a book sales event. This is just for me to establish credibility with the persons out there who are watching this right now. I've also written a book on my own called The Living Trust Advisor: Everything You and Your Financial Planner Need to Know About Your Living Trust. If you go on Amazon, you'll look at my name, you'll see these books that are there. And again, I'm telling you this to establish credibility, not to sell books. Okay, normally my talks that I've given, when I say normally, pretty much every talk I've ever given, has been about how to leave money and property to your children in such a way that it doesn't create divisiveness and conflict in the family. Because I'm fond of saying that the family side of inheritance planning is just as important, if not more important, than the money side. You know, avoiding probate, saving estate taxes, all of that. And I've become quite renowned in that field, in the human side of inheritance planning. But what we're going to be talking today is money. It's about saving money for your family. As a matter of fact, it's really more about saving the family home in light of the new law that was voted into law by the voters of California in the last election. If you're watching this and you live if you live in another state, all of your properties in another state, you don't have to keep listening or watching because that's not relevant for you. But this talk is relevant for everyone who owns real estate and wants to transfer that real estate to their children after their passing. I will go on record as saying that in my entire 32-year practice, I have never encountered a more significant change in the law than Proposition 19 that was, as I said, passed by the voters just this last November. Why? Well, one of the things that I do is estate tax planning to transfer, helping clients transfer what they own to their children and grandchildren or other heirs with the least amount of tax cost. But in order to have an estate tax problem, you need to be wealthy, especially in light of today's estate tax world. Right now, you can pass up to $11.5 million to your children or other heirs without incurring what they call an estate tax. Some people call it a death tax, but it's a wealth transfer tax. But how many people does that apply to? Not that many. In America, it may apply to maybe 0.002% of the populace. But Prop 19, this affects everybody. It is a significant and impactful law that may cause people to have to lose the family property after clients die, after dad and mom die. So what is this? Let's talk about what the law is now before the law changes. This is the property tax law. Before that property tax law changes on February 16th of next year. Right now, you can pass your residence after your death to your children without a property tax reassessment. So if you have a property, if you have a house, say you have a house in Santa Monica and it's worth, well, Santa Monica values are crazy. Say it's worth about $3 million for a teardown. And then that property is, and you bought that property for, I don't know, in 1801 for $30. And your property taxes are based upon that $30 value plus the yearly 2% increases that are allowed by Prop 13 from a long time ago. So your property taxes are very low in that house. Right now, oh, I have to close. Right now, when you die, you can transfer that house, your house, to your children, and they will still pay the same property taxes that you do. The very low assessed value stays with the property when it goes to your children. It goes to them after you die. So your kids can stay in the house and still pay low property taxes. Now there's a philosophical dispute about this. Some people say, well, gee, why should the kids have the benefit of a very low property tax base? And that's beyond the scope of this talk. This talk is designed to make you aware of the problem and come up with solutions to resolve the problem. But anyway, that's the law now. Your principal residence goes to your children after you die with no reassessment, no property tax reassessment. In addition, if you have property other than your principal residence, such as an apartment property, a commercial property, some income-producing property that's not your residence, you can transfer that income-producing property to your children after you die. And if the assessed value of that non-residence property is $1 million or less, then there will not be a property tax reassessment on that transfer, that after-death transfer to your children. Now, assessed value is not fair market value. Assessed value, if you look at your property tax bill, you will see the assessed value in there. So if you have an apartment property that you bought 20 years ago, and it was assessed for, I don't know, $400,000, $500,000, and the property right now is worth, $4 million, the $4 million fair market value is not assessed value. The assessed value is different. It's lower. So that 400, so since the assessed value of 400,000 in this example is less than $1 million, then that will go to your children without any property tax reassessment after you die. And that's the way the law is now. Now, this is the way the law has been my entire 32-year practice. And I have dealt with the assessor so many times. I would say maybe 10-15% of my practice is dealing and having interactions with the assessor in order to ensure that folks are qualifying and getting their parent-to-child after-death transfer property tax reassessment exclusions. That's what I do. But Prop 19 represents a revolution in this area of the law. What does Prop 19 do? It says that starting in February 16th of next year, there is no longer any parent-to-child reassessment exclusion for transfers of non-residential real property. So if you have that apartment property, or you have the commercial property, or some other income-producing property, when you die and that property goes to your children, they will receive a stepped up, that's the wrong way. They will pay property taxes based on its fair market value at the time of your death. That's the first revolution. The second revolution is regarding the transfer of your house. You transfer your house to your children after your death. Your children, in order to receive a quite watered down reassessment exclusion, that property, that house, your house, not only has to be your house at your death, but your children have to make it their house too, in order to qualify for the parent-to-child reassessment exclusion on your principal residence. And if they do use it as their principal residence, well, it's not a full 100% reassessment exclusion. It's based upon, this is an oversimplification because the formula is fairly complex, and if you want to talk to me later, I can certainly tell you. But in a nutshell, it's only the first $1 million of fair market value that's excluded from property tax reassessment. Now, that may sound like a lot, but if you live in the west side of Los Angeles, then where property values are commonly, in the millions, even for 2,500 square foot properties worth 2 million, 3 million, what have you, that first $1 million is the only part that's sheltered from the reassessment that qualifies for the reassessment exclusion. Anything over that, that's going to be reassessed. Again, that's an oversimplification, but for explanatory purposes, it is it's a real thing. So that's the new property tax world we live in, and this begins February 16th. Why? because that's the date that was set forth in the ballot measure, Prop 19 ballot measure. So we have until February 16th, actually before that, because any plan that we implement to avoid this new law that will jack up the property taxes big time, that plan has to be prepared in mid-January, because these plans involve going and recording documents with the recorder's office. Don't you think that there's going to be a million people trying to record deeds to implement some property tax savings plans before February 16th? You betcha. So in order to ensure that the deeds are recorded before the February 16th deadline, then we have to come up with these plans by, I would say, mid to end January, minimum. So that's the new world we live in, property tax world. And as I said, it's a revolution. So, as my father used to say, 95% of the solution to any problem is recognizing the problem in the first place. And then the solutions are the 5%. Solutions should be easy. Well, they're not necessarily easy in this case, and they're somewhat drastic. But we have to fight fire with fire. And I have made it my business since Prop 19 was passed to become a student, or attempt to become a student of this problem and the solutions, in order to be able to advise you, the ones whose kids may have to sell the property after you die because they can't afford the jacked up property tax rates, in order to come up with a solution to try to prevent that. Like I said, the solutions ain't easy, but they're either easy and drastic or not easy and drastic. Anyway, the point is, let's talk about the easy one first, and the most obvious one. You're thinking it right now. It's, hey Jeff, why don't we just prepare a deed? Why don't you just prepare a deed which transfers title of my house to my child now, record it before February 16th, boom, done, over, history, we got it. And the answer is absolutely. You absolutely can do that. You can give away your house now to your children, have it recorded before February 16th, and you're golden, because that takes advantage of the parent-to-child reassessment exclusion on principal residences now, while we still have it. Okay. But there's a couple of problems with that. And, oh, there's a question. Okay. All right. I will answer that in just a moment. Mary, thanks for the question. There's a couple of problems with that. They might be somewhat self-evident, but you're giving your house to your kids. Do you trust them to ensure that they're not going to sell it to somebody else, give it to somebody else, give it to, you give it to your son, he's married, he puts it in his name, and his wife's name is joint tenants. There's a divorce, she walks away with half of it, there goes the house. And now where are you going to live? So when you transfer your house now to your children, your house becomes subject to their lives and the risks and problems in their lives, bankruptcy, accidents with insufficient insurance, addictions, divorce, remarriage. You don't want to do that to your house. You don't want to do that, especially if you're still living in your house, which is most likely you will still be. And so that's the human problem of giving your house now. Like I said, somewhat self-evident. But here's something that may not be so self-evident. Another problem is that when you give your house to your child, you're not just giving him your house. You're giving him your income tax basis in that property. What is income tax basis? In a nutshell, income tax basis is what you paid for that property. What you paid for it. So if you bought the property in Santa Monica in 1960 for some ridiculous price of $50,000. That's what you paid for it, and that's your basis. Why is basis such an important concept? Because when you sell that property, there's going to be a capital gain tax on that sale. And that capital gain tax is based on the gain, the profit on that sale. What's the profit? The profit is what you sold the property for. So let's say you sold your property for $2 million minus the basis. And in this example, the basis is $50,000. So your profit on that sale, I was an English major, so I didn't have to do math, but that's 2,400,000 and I don't know, something is, I'm not quick on the draw when it comes to math. But anyway, it's a significant gain, and that's the profit. And there is a capital gain tax on that profit. And in California, between federal and state, that capital gain tax could be 33%, 35%, something crazy. Okay. So when you give your house now to your child takes your basis in that property. So what happens? Your child then sells the property, whether during your life or after your death. And since he's got your $50,000 basis in that property, now he sells it for $2 million, $3 million, $4 million. Now he's going to have to pay a massive capital gain tax. There's a way around that, which is right now under federal income tax rules. There's something called stepped up basis on death, which means that if you have that, you're alive and you have that $50,000 basis in your house and you die, your $50,000 basis steps up to whatever the fair market value is of that property at the time of your death. So you die, property still owned by you, basis, you still own the property, basis steps up to, let's say the property value is $2 million. And then your son, 5 days after your death, sells it for $2 million. $2 million, thank you, $2 million sale price minus $2 million basis equals zero profit. Therefore, zero capital gains tax. Why this long spiel about basis? Because when you give your property to your children now, they lose that stepped up basis. They lose that significant income tax savings. Okay. So there are those two problems with giving away your property now. Now, maybe your basis isn't that low, or maybe your house has been in the family for generations and you just know your kids will never sell, and they've told you they'll never sell it. Okay. Then maybe the deed process, just a simple deed, transferring it now before February 16th, maybe that's for you. I know I've already done 5 of these since the law has passed. And these are people in a situation where they just know or are taking the risk that the property will not be sold by their children, that because maybe the children already live there, or the children have no other place to live after the parents die, whatever. So that's one solution. It's the simplest solution there is. Before February 16th, deed it over. And then I've had some people ask, well, Jeff, what about a life estate? What if I give, you're so concerned about me getting booted out of the house, and you're so concerned about basis. Well, I have a friend of mine who told me that I can do a life estate on my property, which is simply having a deed and transferring the property by deed to your children, but the deed retains a life estate for you so that you actually have the legal right to reside there for the rest of your life. And that people think erroneously that will take care of the problem. And this, of course, would be before February 16th, the problem of keeping a stepped up income tax basis and not getting booted out of your house. That is wrong. That will also create a situation where you qualify for the present parent-to-child reassessment exclusion before February 16th. That is wrong. And the reason why it's wrong is because the assessor says, the Los Angeles County assessor says that when you retain a life estate, that is not a change of ownership for which you can apply the present parent-to-child reassessment exclusion for principal residences. It is not a change of ownership. What we're looking for is a change of ownership before February 16th, because only if we have a change in ownership now do we have an ability to paint that transfer with parent-to-child reassessment exclusion. When you retain a life estate, it does not work. It is not a change in ownership. So you're doing that life estate for nothing. So if you have this misapprehension that the life estate works, because I've heard, and the reason why I'm spending so much time is I've heard this a lot from people say, oh, I have a life estate, I'll just get, no, it won't work. Save your money. So here's what I've tried to become a student of since Prop 19 came down. I am trying to come up with a solution, not just me, but also my estate planning attorney brethren, to come up with a solution to try to have our cake and eat it too. A solution that still must be done before February 16th. But when I say have our cake and eat it too, I mean to accomplish two goals. One, to have a transfer of the principal residence be a transfer that is an absolute change in ownership, so we can use the present rules of parent-to-child reassessment exclusion and also still retain the stepped-up income tax basis of that property on your death, so that if your child then sells the property after your death, then you get the stepped-up income tax basis, and there will be no capital gains tax or minimal capital gains tax. That's the goal. That's the sweet spot. That's what we're trying to do. And in trying to become a student of this, I have gone through so many permutations with other lawyers talking about, well, what about this? What about this? What about this? And there are some great solutions out there. They mostly involve a trust. And this trust, for purposes of this chat, I'm calling the incomplete irrevocable gift trust. Incomplete irrevocable gift trust. And the solution lies within the body of this trust and the terms of this trust that are contained therein. So we lawyers are talking about these. Okay, will this work? Will this work? Yes, this will. Yes, this will work. We're throwing around fancy words like the grantor mom puts the property in this trust, and she retains a general power of appointment, or maybe it should be a limited power of appointment. And then at the same time, after this is done, mom has to enter into a lease with her kids for less than 35 years to live in there and to retain and to be able to reside in there for 34 years with paying fair market value rent for the first 10 years. And there's all of this technical stuff that we lawyers are building into these trusts, which I am calling the incomplete irrevocable gift trust. There's all kinds of names out there. There's the intentionally defective grantor trust. Whatever. Rose is a rose is a rose. The concept is the same. The concept is that we put this property, we take your property, we put it in this trust, put it in there, and the effect of that. Questions. We put it in that trust, and then that property stays in that trust for the rest of your life, the grantor's life. And then when and this trust has to be done before February 16th. The deed transfer to the trust has to be done before February 16th. And then the effect is that when that constitutes a parent-to-child transfer. Now, it is a change of ownership now, so that we can paint the parent-child reassessment exclusion on that now, while after you die, getting that stepped-up income tax basis on death. And that's the solution. There's other solutions. And like I said, I know I'm skipping a lot of detail, because not only is it seriously boring, but it's also seriously complex. And that's something I am happy to go over with if you want to give me a call or email me later. Happy to do so. That's just not, I think, that's just beyond the scope of this chat, which is an issue raiser. I'm raising these issues for you, so then we can then talk about the solution. There is another solution, and it involves entity planning. If you want to know what the big boys are doing about this, if you want to know what the rich people are doing with those big Century City firms, it's called entity planning. And just a little taste, and it doesn't involve parent-child reassessment exclusions. This doesn't have to be done right now prior to February 16th. It has to do with proportional interest transferring from one set of people to another set of people. I know I'm being intentionally vague, but there is another solution out there, and it involves entity planning. But whatever these solutions are, I have to come up with a caveat. I was speaking with another lawyer about all this yesterday. She had attended the same Zoom seminar with the head assessor guy of Los Angeles. His name is Jeff Prang, and he was on this Zoom seminar last week. Nice guy, nice staff. They have an impossible task to do. I know I've been at war with the assessor for 32 years, but I'm at war with them as a concept, not with the people there. They're the nicest people in the world, and they are there to help us. They're there to try to give us the goals that we are attempting to accomplish, which is to avoid property tax reassessment. So they're on our side, if you can believe it. Yes, they love to, they want to reassess, because the more reassessments, the more money for our government, the more money for our programs, police, fire, civic, all that stuff. But they're also there on our side as well, because if they say if there's an exclusion from reassessment, they want us to succeed in applying for that. So good people. But when we threw at them all these questions about, well, will this work? Will this grantor trust work? Will this limited power of appointment work? Will this 34-year lease work? Will this entity planning work? Their answer was necessarily the same, which was, this is all still new. We've received no clarifications from the legislature. We don't know if any of those plans, Condon, that you're asking about and your other estate planning colleagues are asking about, we don't know if these are going to work. We just don't know. So folks, we're up. This is sort of we're in a bind. We have a February 16th deadline to implement these plans and to record these deeds and to do these trusts and to do this entity planning. But we have no assurances that the assessor will go along with these plans as far as achieving our goal of painting property tax reassessment exclusion now, parent-to-child exclusion now. It's novel. It's a gray area. It's untested. We lawyers are talking amongst each other. We said, we think this will work. We think that, because we have this case, we have this annotation, we have this Internal Revenue Code procedure. We think, and we've had our past experiences dealing with the assessor and their opinions on prior matters. But all this, it's more than conjecture, but it's not definite. Did Snoopy fall down? So, is there anything you want to tell me, Marpels, right now?
No, just the questions.
Okay, all right. I'll get to the questions. So, this is there's a word for it. I'm just escaping me right now. It's Faustian bargain. I don't know. But anyway, here's the thing. You may be throwing money at a lawyer to come up with these plans. And that's great for me. I mean, gee, that's terrific. Being a little facetious here. But when we do these plans, there's going to be these massive CYA, cover your ass, documents that say this may not work. But if they don't work, what's the worst that could happen? The worst that could happen is that you don't get the reassessment exclusion. That's pretty much it. I guess the worst that could happen is that you just thrown billions of dollars at an attorney and the plan didn't work. Well, my view is, and again, this is coming from the perspective of somebody who's been dealing with the assessor for a long time, is that you got to do something. Because you have to, because if you don't do something, if you don't try something, then the house that you have, the income producing property that you have, that you wanted to transfer to your kids, may not be able to be kept by them because they may have to sell it because they can't afford to pay the property taxes. In addition to the other costs of maintenance, you know, the mortgage, the insurance, the homeowners association fees, whatever. So this is all about preserving the family home in the family. This is about preserving the income producing property in the family. If you want your house and your income producing property to be your pyramid to your future generations, because that's the expectation. Whereas then this is the property tax tail that's wagging that dog. Because a lot of times the kids are going to have to sell the property because they can't afford to pay. And this is why this initiative was on the ballot. Who do you think brought this up? It's the Realtor Association. They're saying, hey, we need to find a way to make more commissions. That means more sales. And that means that people, you know, if they can't afford the property taxes, they're going to sell those properties. Blame the realtors. Anyway, so this is the concept. I want to get to some questions. Joan Santon, what about property currently in an irrevocable living trust? Doesn't apply. You are your trust. Your trust is you. That is, when I say it doesn't apply, that means that is not one of the solutions that we have that can be engaged with prior to February 16th. It's not a irrevocable defective grantor trust. It's not an irrevocable incomplete gift trust. So the property in the trust, you know, if you die after February 16th with your property in your living trust, that's not going to qualify for the parent-child reassessment exclusion. Let's see. Stephen Johnson. Go SCAC. That's my master swim club. Doesn't the basis step-up market at the time of death, so-called angel of death step-up law? Yes, it does. That's what we're trying to preserve with these solutions, not only to try to qualify for the parent-child reassessment exclusion now, prior to its demise, or its near demise in February of next year, but we're also trying to preserve the stepped-up income tax basis. Okay. Lisa, if the home is left to 3 children and only one stays living in the home, does the reassessment exclusion still apply? No. No. If you leave the home to all 3 children have to live in the home for the new post-February 16th parent-child reassessment exclusion to apply. And here's a question that I guess you're asking yourselves. Hey, I'm the child, parent dies, I'm saying that I live in the home, but I really live in Wisconsin. But I'm going to say that I live in the home. How is the assessor going to know that I'm lying? Okay, is the assessor going to come out and check to see if you're living in the home? And again, you have to be for the residential parent-child exclusion. It has to be the parent's home. Parent dies, and now you have to be living in that home. Is the assessor going to come around? No, the assessor is not going to come around. How long do you have to move into the home? The assessor says about a year. You have a year from the date of your death, mom's death, parent's death, to live in the home. How is the assessor going to know? Because you, the child, are going to sign a document under penalty of perjury that says that you are using the house as your principal residence. How are they going to find out if you're not using it? Well, maybe they never will. But one thing I've learned in 32 years of dealing with the assessor, don't mess with the assessor, because they can find out. There are ways to find out, and I don't want to push that envelope. So so you're signing under penalty of perjury. Let's see. More questions. Let's see. I have from Lydia. I have the reassessment exclusion from a family home that my parents left me. Trust has been dissolved. I am a legal owner. Will this be revoked? Hey, if your parent passed away, prior to this talk, prior to February 16th, from an assessor standpoint, date of death is the date of the transfer. So if the date of death is prior to February 16th of your parent, then I know this sounds ghoulish, but you're okay. From a property tax standpoint, you're okay. You have you have locked in the parent-to-child reassessment exclusion. Michelle Floria, can realtors use Section 179? Call me later about that. Let's see. Anything else? For how long is the residence? Need to be the residence of the child after death? Well, that's a good question. How long do you have to keep at your principal residence? How long is the assessor going to keep asking you to sign under penalty of perjury that the house is your residence? We don't know. But the chances are that if you use it as your residence and then you no longer use it as your residence, then there's less of a chance of the assessor finding out about that. That's my diplomatic answer in case Jeff Crane is watching. Let's see, because I'm an officer of the court. I am not telling people to violate the law. I do not want to have that. I don't want to have the state bar after me. Okay, so all right, folks. This has gone on actually about 10 minutes longer than I anticipated. I just wanted to raise the issues and then come up with the concept of the solutions. Oh, my father's property was a transfer to me prior to his death. Does Prop 19 apply to me? Yes, it does. No, it doesn't. No, it doesn't. You've locked it in. Your parents' death locked in the date of the transfer. Yeah? I think you gave this to you before, right? You did. Yep, you did. Yeah. I couldn't do what I do without my secretary, Marbella. She's terrific. She's been with me for how long, Marbella? 15 years? Okay. All right. Then, okay. Doesn't seem like it, does it? So anyway, all right, folks. Here's the deal. If you want to talk to me, there's no charge just to get me on the phone or for some quick email exchanges, or to meet with me. In today's world, it's all Zoom meetings, and but if you do want to come in, you have to wear a mask, and you have to sit 6 feet away from me, and I wear 2 masks, so that's not a problem. Or I live 2 minutes from here walking. We can meet in my backyard. So we can chat. There's no charge for that first consultation regarding this, because I can't charge you a fee to tell you what the fee is going to be, and only in that first meeting am I able to discern and glean your needs, your particular situation, particular solutions, and then I can quote a fee. And let's see. So another question coming up. Carrie Ross, once children move in, isn't that 1 year minimum occupancy a permanent requirement? We don't know what the requirement is. We think it's going to be 1 year. 1 year minimum occupancy is a permanent requirement. We just don't know yet. Just don't know. Okay. But you should at least live there for 1 year. 1 year. That's what we're thinking. And another question. Let's see. Once children, okay. Say again a brief summary of what is needed for a trust to protect the property transferred to kids. This is the greatest hit of the solution to this problem. The solution to this problem in concept is you taking your house or your income producing property and transferring it to a trust, an irrevocable trust, which means you can't revoke it. But we give you enough powers over the assets so to take the position that this property is still yours from a capital gains tax, stepped up income tax basis standpoint, while still giving basis for the assessor to rule that it is a change of ownership between parent and child prior to February 16th. That's the nutshell. I hope that wasn't too... Joe Deering. Oh my gosh, Joe Deering. What about an occupancy agreement? As part of this trust, Joe, as part of this trust, and by the way, Joe Deering, Santa Monica High School, you know, I thought I was wearing my Samo High tie here. You know, I went to Samo, Joe went to Samo. We got a lot of Samo High alumni on here. It's great to see you all. And I'm a vice president of the Samo High Alumni Association. And Joe was given a citizenship award from the Alumni Association a couple of years ago. It seems like 1,000 years ago now, but Joe is one great guy. And also a fellow estate planning attorney. Joe, the occupancy agreement from all of my learnings has been that it cannot be for more. So when you transfer your property to this trust, there has to be a lease, an occupancy agreement that goes along with it, so that you have the right to reside in your property. But that lease agreement cannot be for more than 34 years. And you, Joe, let's say you're the one that's still living in the property because you've given away your property to this irrevocable trust. You have to pay fair market rent for a little while, maybe a year. You have to pay fair market rent, and that whole package, that irrevocable trust and the lease, that combined will give rise, or excuse me, may give rise to a decision by the assessor to say, hey, this does qualify prior to February 16th for the parent-child reassessment exclusion. I hope that was responsive, Joe. Glenn Sato, volleyball, the famous Sato family in Santa Monica. What information do I need to bring to the first meeting? Just bring yourself and just your general knowledge of what property you own. If a child is on title as joint tenant on parent's home, will Prop 19 still affect the child? The child does not live in the home. So, so right now, we got mom and child on the property, on the house, as joint tenants. Joint tenants. Mom dies after February 16th. So that property goes to the child. Based on what I know now, that if the child moves into that home within a year of mom's death, then it will be partially excluded from property tax reassessment. Remember, that property tax reassessment on the principal residence is only up to, again, from a general standpoint, it's only up to $1 million of fair market value. Oversimplification, I can get into detail later. Okay, what if we do this? Then the adult child dies, and we have specified in the trust another relative to inherit the property. No. Can the irrevocable trust specify a series of relatives? No. The beneficiaries of the irrevocable trust must be the children. It must be the children. Not only must be signed and implemented prior to February 16th, it must be the children who are the ultimate beneficiaries of that property. That's the only way it's going to qualify for parent to child exclusion now. There's something else I wanted to say. Well, can't remember. So anyway, all right. Well, folks, I hope I've done my job in raising the issue. I hope this hasn't been boring because I have a saying, I don't like to be bored. I don't like to be boring. And I try to convey good information and to make the time that you spent with me meaningful. That's where I feel I've done I've done my due diligence, and I've, maybe somehow in some weird English major way, which I was UCLA English major, given back to society. So, I'm obviously there's a business element in anything we do, but and of course I'm happy to have your business, but this isn't a business acquisition thing. I am here to convey this because I have just been, like I said, battling with the assessor for so many years, and for this parent-child exclusion to be taken away from us is such a sea change. It's such a game changer that I just felt compelled to do something, to say something, to try to bring this to the attention of everybody. And so, like I said, give me if you have more questions, give me a call, email me, meet with me, and I'm happy to do so. I want to thank my secretary and her lovely husband, my tech guy, for helping me get this going, because I am very technologically illiterate. And I appreciate your time if you stuck with me this far. And oh, one more thing. Oh, get my contact info. Okay. My telephone number is 310-393-0701. Yeah, 310-393-0701. And my email address is, I'll say it and then spell it, jeff@condonandcondon.net. That's jeff@condonandcondon.net. jeff@condonandcondon.net. Website is condonandcondon.net. Once again, I appreciate your time, and thank you all, and have a safe day, a safe holiday season, and let's all take this pandemic seriously, okay? Okay, bye now. God bless. If you end this live video now, you'll be able to choose if you want to